And now the next case.
All parties in the matter of Sparks versus Stevens. Step forward, please.
22-year-old construction worker Chris Sparks is suing his former friend, 22-year-old student Sean Stevens, for the cost to fix his truck. Chris says the truck was damaged while in Sean's possession.
Mr. Sparks, when were you beaten up at this bar?
In late December, early.
Give me the date, sir, not late. Give me the date.
It was about December 20th.
Is that right?
November 21st.
Does that sound right to you, Mr. Sparks?
Yes.
You were beaten up, I gather, pretty badly, so that you were hospitalized. Is that right?
Yes.
Now, the defendant was a friend of yours. Somehow he was contacted and came to the bar where you were. How did that happen, Mr. Stevens?
I was at my house with my girlfriend, and then I got a phone call from a buddy of ours and from another random person I've never met before. They called me and told me that Chris had been beaten up really bad and I needed to come down. Came down, went inside the bathroom. And
okay, so you came down to the bar. How did you find Mr. Sparks when you got there?
When I arrived in the parking lot, everybody that was inside the bar was outside and told me he was in the bathroom. I ran in the bathroom. There was blood all over the place. He was lying on the ground.
Where was he bleeding from, Mr. Stevens?
He was bleeding from the back of his head, by the skull.
What about on his face?
All over his face. Here, everywhere.
Was an ambulance called?
Not personally by me, but by somebody that was there.
Did you accompany the ambulance to the hospital?
No, I didn't. They wouldn't allow me. Chris told me to take his truck and drive it down to UCLA Medical Center where the paramedics told me he would be. They flew him in a helicopter down there. And
oh, they took him by helicopter?
Yes, ma'am.
So you must have been in pretty bad shape, sir.
Yes.
And do you recall telling Mr. Stevens to take your truck to UCLA Medical Center?
No, because I was in and out of consciousness the whole time.
In and out of consciousness and in and out of sobriety, I assume, as well.
A little bit of that, too.
Judge Judy continues in a moment.
Your deputy, and obviously, is on your side.
My deputy, of course, is on my side, because most normal people would be on my side, because when you pass a car, you can't pass a car on both sides unless you're flying on top of it like Dumbo.
Real cases, real people. Judge Judy. Chris Sparks is suing his former friend, Sean Stevens, for the cost to fix his truck. Chris says the truck was damaged while in Sean's possession.
So this is what this case is about, Officer Byrd. Listen to me very carefully.
Okay.
He gets a call late at night. He's with his girlfriend. He leaves his girlfriend. He comes to the bar where this guy was probably drunk as a skunk, got into a fight with somebody in the bar, and they pulverized him in the bathroom. Mr. Drunko over here asks him to please take his truck and drive it to the UCLA Medical Center. He does that. This is on November 21st.
Okay.
On November 23rd, he drops the truck off at one of their houses, either this one or the father over here. And they notice that the truck is damaged on the side. And they want Mr. Stevens to pay for the damaged truck. That's what this case is about. Isn't that right?
Yes.
No good deed goes unpunished.
Right. So now, Mr. Sparks, I would like for you to tell me, sir, why you think Mr. Stevens is responsible for the damage to your truck.
Well, the reason I think he's responsible is it was in his possession. My dad saw the truck at the hospital. It was not damaged. And
oh, really?
yes.
I'd like to hear that. Well, not that it's dispositive of this case, but I would like to hear that. Step up, Mr. Sparks.
Yes, Your Honor.
So you get to UCLA when, sir?
I arrived at the emergency center at about 2:30 in the morning.
In the morning?
Oh, yes.
Really? And I assume that you had gotten a call. You were pretty upset.
Very upset. Oh, God.
So what happened when you got there, sir?
Well, parked the car, and then between my car and the entrance to the emergency room was the truck was parked where Sean had parked it. And on the way by, I happened to notice it and noticed that there was no damage. You know, everything seemed normal with the truck.
You went on both sides and noticed that?
Well, walk by and you see the driver's side and then you see the passenger side.
Really? How do you see the driver's side and the passenger side walking by it?
Cars pulled into a space like this. You walk by like this.
Yes, you see one side of the car.
And then you see the other side.
How do you see the other side?
You turn and look. I happened to notice that it was Chris's truck.
You're a liar.
No, I'm not.
Oh, yes, you are. Either you're a liar or you're a lousy father. Which one are you?
Not a liar. and a great
Which
father.
one? No, you're either one, sir. Because if I got a call that my son had been airlifted to UCLA Medical Center because he was injured, the last thing I would do was to glance back to make sure that the truck was okay. That's the last thing I would do.
Well, Your Honor.
That's the last thing I would do because there wasn't any indication that he was in an accident in the truck. So either
Your
you're
Honor.
lying about seeing it or you're lying about being a good father.
No, I did not double back. On the way by the car, I noticed both sides of the truck. Your deputy, and obviously, is on your side.
My deputy, of course, is on my side, sir. You know, I don't know why? Because most normal people would be on my side because when you pass a car, you can't pass a car on both sides unless you're flying on top of it like Dumbo.
Well, Judge, all I can do is
Like
tell you what
Dumbo. Then maybe you could see the top and maybe you could see the sides.
Judge?
Other than that, when you pass by a car, you can only see one side.
Judge Judy continues in a moment.
Okay, I was just curious to hear what you had to say, sir. I was curious to hear how you justified going in to see your son, who has recently been airlifted to an emergency room, and checking to see if the car was okay on your way inside. Not that it's dispositive, because maybe after you got inside, somebody came by while the car was in the parking lot and sideswiped it. Is that possible?
I guess it's possible.
Of course. Now, when you got there, was Mr. Stevens there?
Oh, yes. And glad,
Did you
glad
say,
he was there.
listen to me carefully, sir. Did you say to Mr. Stevens, thank you very much. What can I do to help you? Can I drive you home? Thank you very much for being in the truck here. Is there anything that I can do?
Well, my first concern was after seeing my son,
No, your first concern was looking at the truck, according to you.
and when I was in the room. The first, after I saw Chris, then that's all I was worried about. And I appreciated Sean. You know,
Good. So you appreciate him so much you're suing him.
well,
Is
if the
that
truck
right?
is damaged,
What?
what do you expect me to do?
I expected you to pay for it, and thank you, lucky stars, that your son is standing next to you. Case is dismissed. Goodbye.
Parties are excused. You may step out.
I'm trying to help a friend out.
Think it turned out bad.
I guess in his eyes, we obviously weren't that good of friends.
She didn't choose to believe it.
I miss his friendship.
It's over.
I'm happy it's over with.
And now the next case.
Parties on Walker versus Demby. Step forward, please.
24-year-old certified nursing assistant Latoya Walker is suing the mother of her husband's daughter, caregiver Teresa Demby, for kicking in her screen door. Teresa says she didn't do it.
Miss Walker, it is your claim that the defendant kicked in your screen door. You wanted to pay for the damage.
Yes.
Defendant says it wasn't me. You probably did it yourself. How do you know her?
My husband has a baby by her.
Your husband. This is the husband. How long have you been married?
Maybe a couple months. We got married in March.
How old is the baby?
She's 3 now. She just had a birthday.
Who does the child live with?
Her mother.
She always lived with her mother?
No. She just got her on the 24th of May.
Prior to the 24th of May, who was she living with?
Me and him.
How long had she been living with the two of you?
Since she was 7 months.
So you were in court over a custody case?
They were.
They were. And ultimately, your daughter came to live with you.
Yes, ma'am.
Father have visitation rights with the child?
No, not by the courts or anything. It's just that if he calls sometime, which he doesn't really, to see
So
her.
he doesn't have a visitation
No.
order?
No.
When did this door incident take place?
On April 24th of this year.
At that time, you were involved in the court case, is that right?
I had put in a motion then. A motion was put in.
So the answer is yes,
Yes.
you were involved in court. And the child was living with you.
Yes.
So tell me what happened.
So she called that morning and she asked me, was Shaniqua there? I told her no. So she found out I was lying because the baby was there.
Why did you lie to her?
Because she hasn't been coming to get her for her weekends, and I just felt that I didn't want her to, I don't think that she should have seen her. We always get her ready to go where her mom, she'll never show up when she's supposed to. When she do show up, she's late. She bring her back late.
So you lied to her and told her that the
Yeah, I
baby
told
was...
her that the baby was at her grandfather's house, her great-grandfather's house.
What happened next?
So she figured out that I was lying because I guess she went to the great-grandfather's house and she called me and she asked me did I have a problem with her. And I said no, but I got a problem the way you treat Shaniqua. And she said, what you mean you got a problem with? She was like, wait a minute, I'll be right over.
Real cases, real people. Judge Judy. Latoya Walker says her husband's ex-girlfriend, Teresa Demby, kicked in her screen door. Teresa says Latoya lied about the whereabouts of her child.
Go ahead.
So she came over, we exchanged words, you know.
Where was she and where were you when you exchanged words?
At my door, because my screen door don't have the part where you could talk through. It's just like the glass up top. So I had to open it a little bit just to even to talk to her.
So?
Then she started calling my husband names, a liar, and, you know, calling him names, assaulting him and all this stuff. So I said, well, the conversation is closed. I'm not going to let you talk to my husband like that, you know.
Where was he?
He was at the doctor's that day.
So he wasn't home?
No, he wasn't home.
So she was just bad-mouthing your husband to you? Okay, next.
So then I said, well, I don't want to talk to you, because at the time my baby woke up and everything. So I just said, I don't want to talk to you no more. I'm shutting my screen door. And she slammed it. She said, I'll shut your screen door, because she was holding it, you know, talking. And then she was like, matter of fact, I'm going to kick your screen door. So she started kicking it, and I started laughing. And I said, and I got on the phone and I called 911. And she said, call your husband, call your husband. She think I was calling him. I was really calling the cops.
Did they come? Did
Yes.
they arrive? You have a report?
Yes, I do.
Can I see it, please? So she kicked the door?
Yes.
And then she left?
Yeah, she left when she, you know, realized I was talking to the cops because I was looking at her tag number.
Anything happened as a result of this complaint?
Well, I had filed another complaint, but apparently I was at the wrong court because their judgment was that we needed mediation to deal with the baby.
Okay, I'm not talking about the baby. I'm talking about this
So
vandalism complaint. Okay, do you have pictures of the door?
Yes.
And do you have an estimate for the damage?
Yeah.
Okay, now I'll hear you.
All right, how you doing? First of all, I seen Mr. Walker, my daughter's father, that day, and he said that Shaniqua was home to give her a phone call. So I gave Shaniqua a phone call, and she answered the phone. I said, can I speak to Shaniqua? She said, Shaniqua's not here. Shaniqua's at her grandfather's home. So I goes to the grandfather home. Shaniqua wasn't there. So I called her from the grandfather home, and I asked her, I said, what? I said, do you have a problem with me? And she said, no, I have a problem with the way you treat your daughter. And I said, what do you mean? So we exchanged words on the phone, but I never went out to her home. So then the next time I really seen these people was when I went there with the police to get my daughter after the custody hearing that he did not show up at. It's all basically over. She doesn't like my daughter. My daughter's only 2 years old. She was abusing my child, and I wasn't going to let my child stay there and be abused. So this is what this is all over. A 2-year-old girl that he has a baby by me first and not her. So she made it her business to go out and have a baby. Fine, fine and dandy. So, you know, you mistreating my child. Every time I turn around, you
Listen to me.
Yes?
Listen to me.
I don't know anything about the screen door.
The police report was made on the same day as this incident, on the 24th. On the 24th, the child was still living with them.
Mm-hmm.
Common sense would indicate to me that you were pretty angry when you went over to the grandfather's house and found that your child wasn't there.
100%.
Right. And then what you expect me to believe is that you didn't go over to the house to confront her about lying to you. That's what you want me to believe.
Well, basically, you're going to believe what you want to believe. But
No,
what
I'm just asking.
I went back to my home where I live at in Clementon, which we was already in municipal court for this case. When she came to municipal court, she had no pictures of the door. That's why the judge threw it out.
Listen to me. It's not what I'm saying to you.
Okay, what are you saying?
You want me to believe that after she gave you the runaround and said that Shaniqua is not at her house, the grandfather's house, first she lied to you, then she sent you on a wild goose chase to go and find your daughter where the daughter wasn't visiting. You want me to believe that you just merely accepted that and went home.
I just want you to believe the truth. That's what happened.
I don't believe you.
Okay.
Judgment for the plaintiff in the amount of $324, which is the amount to fix the door. Thank you. That's all.
Please excuse. You may step out.
They just mad because they can't abuse my daughter anymore, and she's a liar. That's it.
She got history of all that kind of stuff. I'm not here to make her look bad, because she just made herself look bad.
He come to me complaining about his wife. She's just jealous because I got his first child.
He's always going to be the baby's father. That's always going to be his baby mom, and that's it.
He's not allowed to see my child. He's not going to see her, and she's not going to be around her, and I have no reason to go around them ever again in life.
Take care of your child in the beginning. You ain't got to go through stuff like that.
Stay away from people like them.
Woo! Be a mom.
24-year-old surgical assistant Kimberly Orell is suing her ex-boyfriend, 22-year-old security officer Robert Stewart, for an unpaid loan and for his share of a trip to Disneyland.
Order. All rise. Yeah, this is case number 5 on the calendar in the matter of Orell versus Stewart. Parties have been sworn in, Judge. You may be seated, ma'am. Have a seat.
All right, let's see how quickly we can do this. Ms. Orell, according to you, the defendant is your ex-boyfriend.
Correct.
And he owes you some money. I did the math. I don't quite see where you come up to $5,000. I'm sure you're going to try to explain that to me. The money comes from 2 sources. One, you claim that you went on a vacation together, and he was supposed to pay you for at least half of the vacation or the whole vacation, and he never did. The vacation, according to you, was under $1,000.
Correct.
And the second thing was a loan that you made to him for some furniture for his new apartment. That was $190.
Correct.
Tell me about the trip. When did you take it?
We went on May 22nd of 2000.
Okay, what were the circumstances surrounding the trip?
He was just beginning a new job. He was supposed to start the following week. We had some time off. He had told me that for many, many years during his childhood, he had wanted to go to Disneyland. He had never gotten the chance to go, and we would like to go, with the understanding that since...
No understanding.
Okay.
He would like to go on the trip.
Correct.
I want to hear your version of the conversation.
Okay.
I don't want to hear your understanding.
Okay.
Go ahead.
He did not have the front money to go on the vacation, but if I would agree, I agreed to put it on a credit card, in which case there was a payment plan and that it would all be paid back in the next year.
He said that to you?
Correct.
You got your bill from your credit card?
Yes.
How much was the total trip?
The trip alone, $960.
Did you show him the bill?
I did.
And what did he say?
He said no problem. He began his payments, and it was
How many
actually
payments
fine.
did he? How many payments did he make?
He made 2 payments directly on his paid dates.
How much?
The very first one was $40. He followed with $20.
So according to you, he paid $60 in total.
There was another $20 payment weeks later. There was $80 total.
Okay. So he's making these small payments, and now tell me about the furniture.
We had previously, prior to the
Were
trip...
you living together at the time?
No, we were not.
Okay.
At that time, a couple weeks after we returned from vacation, he did have to leave the residence where he was staying with a family member. And he stayed at my house just for a couple of weeks until he did find his own residence.
And?
And he had come here from very far out of state when he had originally moved here. He hadn't acquired many things other than a bed and such. And being that I had no point to distrust him at that time, I did agree to buy a few things for the apartment for him.
How much did you spend?
It was just under $200.
What do you mean just under $200?
It was the credit card totals of $191.
And he wasn't working at the time?
He was working at the time.
So why didn't he pay for those things himself?
He didn't have any money saved up, and he had made a few payments to me.
Paid $40,
He just had to pay-
$20, $28?
Had to pay rent to get into a new place, too.
Okay. So far, if everything that you say is accurate,
Yes.
it's $191 plus $880.
Okay.
$1,071. So you want to explain to me why we have a lawsuit for $5,000?
Absolutely. There were other very small charges. His pet was hit by a car, had to have emergency surgery. Veterinary clinic needed payment to receive the animal back, things like that, that I did put on. That was just prior to the trip. That was May 2nd. The unfortunate thing is that I had one credit card at the time, and we used that for the entire vacation, and due to the fact that it was in 2000, because of non-payment, I've had interest for over 2 years on a credit card.
Should have paid it off.
Which he agreed to.
You should have paid it off.
You're right.
Right.
If I had the money, I would. You're right.
Shouldn't have gone on the trip if you didn't have the money. He didn't have the money, you didn't have the money, then you don't go to Disneyland. You don't go to Fantasyland if you don't have, neither one of you have the money.
It's difficult to turn down a somewhat free vacation with someone that you do trust. I did trust him very much.
No. Listen to me.
Okay.
When did you meet him?
January.
You met him in January.
Yes.
You're going away in May.
Correct.
Right? January, February, March, April, May. Did he have a job in January?
The entire time, yes.
He had a job in February.
Correct.
March.
Yes.
April.
Yes.
So why didn't he have any money? You told me he was living with relatives.
That was kind of the problem. He never seemed to have any money.
Well, then I don't know. I would begin to scratch my head if I were an intelligent girl.
I did shortly thereafter.
Well, you do it shortly before you expend money.
You're right.
I mean, you wanted to trust him. The fact that you wanted to trust him doesn't mean that you had any cause to trust him.
Right. We had a rapport built up. He borrowed very small amounts in the past, and he paid them back immediately. I had a lot of trust in him at the time.
Well, so then maybe if he borrowed small amounts, he paid them back immediately. Maybe his answer to your lawsuit has some validity. Mr. Stewart, what's your answer, sir?
Your Honor, I'm sorry. Your Honor, we went on this vacation, all right? We started going out on Valentine's Day that February. It was supposed to be like a gift to me, okay?
Why would you make a gift of a trip to you?
Well, Your Honor.
Don't be an actress, please.
Okay.
Your Honor, I love her very much, all right? And I think she felt the same way back to me. And I thought it was just, you know, she knew I was getting stressed out at my job. She was getting stressed out, and she told me it was the happiest place on earth. So, so we decided.
Judge Judy continues in a moment.
I mean, I just have a hard time seeing how, you know, a $400 trip to Disneyland has accumulated to $5,000.
It hasn't.
Okay.
Only in her mind. Only in the fantasy of her own mind.
Okay.
And later today,
I had a lady from Protective Services show up at my door. There had been a conflict at their home, and I was under the impression Teresa was hit, and that's why she came to stay with me.
real cases, real people. Judge Judy. Kimberly Orell says ex-boyfriend Robert Stewart owes for an IKEA shopping spree and for his share of a trip to Disneyland. Robert says Disneyland was a Valentine's gift.
Why didn't you have any money to go?
I just relocated to Oregon, and I guess I just really don't know how to manage my money that well, especially at the time. And
were you using drugs?
No, ma'am.
Well, if you were working, you were living with relatives.
Yes, ma'am.
Right? And you weren't spending a lot of money on the plaintiff. What were you doing with your money?
I really wasn't making that much money at the
What kind
in the
of
first
work were you
place.
doing?
We worked at a detox detention center together.
Were you working 2 jobs at the time?
Shh, I don't speak to him. All right. Let us say that the two of you should not have gone on this vacation together if neither of you had the money. So let's say you split this vacation.
Well, in that case, Your Honor, I mean, I would say that if you did have an agreement like that, it would be a $400 trip. And we got back, and she was having a hard time paying her credit card. I gave her almost $400 to help her out with her credit card in the first place.
Did you?
Yes, Your Honor.
You have any proof of that?
No, I don't.
When did you give her $400? So she said you gave her 80.
It was just over a period of time. Like I give her $50 here, $50 there.
Really?
I mean,
Do
just
you
to help her
remember?
out.
You remember all those times, Mr. Stewart?
Yes, ma'am.
You got a pretty good memory.
Well, it's just, I mean, $400, that's not that many payments of $50.
Is it cash or checks?
Miss,
cash.
are you speaking to him?
I'm sorry. I'm sorry.
I mean, I just have a hard time seeing how, you know, a $400 trip to Disneyland has accumulated to $5,000.
It hasn't.
Okay.
Only in her mind. Only in the fantasy of her own mind.
Okay.
All right. We talk about furniture. You're talking about pots, pans, teacups. What about that?
Your Honor, most of this stuff, she was staying with relatives at the time as well. And she asked me to hold on to it at her place because she had it in storage. I had it in my place. As soon as we broke up, I helped load it up in her car for her, and she took it all back.
What about stuff she bought? Do you know?
She bought a couple of things like plates and such, and, you know, we got it from like one of those dollar stores where they sell plates, you know. And I mean, she did buy stuff for me, but I was under the impression it was a gift. You know,
Did you ever tell her that you're going to pay her back for it?
No, ma'am. There was
I
no
don't
meeting
believe
of
that
the
you did
minds.
either.
Ma'am, I have a witness also.
I'll hear you witness.
Okay, thank you.
Tell me your name.
Heather Walker.
All right, Miss Walker, tell me what you know.
I witnessed a conversation at my home between Mr. Stewart and Kimberly, where he very clearly stated that he knew he owed her a large amount of money. He was going to pay her.
Well, tell me about when that happened and under what circumstances.
It would have been about a week after my birthday of that year because Kimberly and I weren't able to be together.
When's your birthday?
July 11th.
Okay, so in July, You witnessed a conversation. Tell me what you best recall of the conversation.
That they'd visited for about a half an hour. They were going to leave and go to a restaurant. Mr. Stewart said that he did not have cash on him and would Kimberly mind paying for this, whatever they had eaten, and he promised to pay her back.
Now, what did he say? He said, I'll pay you back.
He said, I will pay you back.
I'll pay you back.
Yeah. I'll give you your money back. She made sort of a sarcastic remark about, like the other money that you paid me back.
Right.
That's about the end of the conversation, except for he got a little bit defensive because I asked him why he hadn't been paying. He said, you know what, I don't want to fight about this. Kimberly's already been giving me some guff about it, and I will pay her back.
And did they go out for dinner?
Yes.
And I assume you paid. Right?
Yes.
Your Honor, I don't recall that conversation at all.
I don't recall you paying me $400.
Listen to me. Don't speak to him. Okay. If you wanted to speak to him, you shouldn't come here.
Can I submit a few things to you?
I'm not interested in the few things that you want to submit to me, madam. Let me explain something to you. You had a romance that ended 2 years ago.
Yes.
Put a period and move on.
Judge Judy continues in a moment. And later today,
Do you see your daughter, Teresa?
No, Your Honor.
Why not?
Well, she lived on bad terms, and until she gets her act together, Your Honor, I don't want her in my house because she's a danger.
How's she behaving in your house?
She's a handful.
real cases, real people. Judge Judy. Kimberly Orell says ex-boyfriend Robert Stewart owes for an IKEA shopping spree and for his share of a trip to Disneyland. Robert says Disneyland was a Valentine's gift.
I believe that if the two of you took a stupid vacation together when neither one of you could afford to go on a vacation, the two of you ought to pay for it. I do not believe, Mr. Stewart, and even if I tended to believe that you gave her more money than you said, you had no proof that you gave her more money than you said you gave her, because according to you, she said to you, let's go on this wonderful trip together. You don't go on a trip if you can't afford it. So you have to pay for half the trip, $480, and I give you credit, sir, for the $80 that she says that you paid her back, which means that you owe her $400. Then we get to the quote-unquote furniture. I get the sense that you wanted to help furnish this little apartment for him so that he would be comfortable. Certainly, even if I believe you, and based upon what I've just calculated, I did, he owed you, according to you, $960. So he makes a $20 payment on $960, and you don't look like an unintelligent young lady. He had promised, according to you, to pay the whole thing back in a year. Well, if he makes $20 payments a month, that's going to take him a lot longer than a year to pay off $960. Well, then you're still going out for dinner with him, and according to your witness, still paying the bill. All not very smart. When your head is ruled by your heart, sometimes you do foolish things. And all I can suggest to you, Miss Orell, is that you put a period and move on. Judgment for the plaintiff in the amount of $400. That's all.
Parties are excused. You may step out.
I think it's pretty bad that, you know, you have to go to court to solve some problems that can be solved at home.
Let this be a lesson to people. Don't ever lend anyone money. They'll twist it and return it, and it's just going to be a bad situation either way.
There was no money owed, so there's no payments to be made.
Don't lend money to your firstborn. It doesn't matter who it is. Don't do it. You'll get hurt.
And now the next case.
All parties in the matter of Chandler versus Chapman. Step forward, please.
Teacher James Chandler is suing the ex-wife of his girlfriend's son, 21-year-old collections agent Trista Chapman, for wrecking his car. James says Trista took the car off-road and broke the axle.
Mr. Chandler, the defendant was driving your car and wrecked it.
That's correct, ma'am.
And you want her to pay for it.
Absolutely.
You didn't give her permission to drive your car.
That's correct.
How do you know her?
She is my girlfriend's son's ex-wife.
Girlfriend's son's ex-wife.
At the time they were estranged.
Now, I'm going to make a guess that the son's name is Brian.
Correct.
Because she says she had Brian's permission to drive the car. So you tell me how that came about and why you don't think you're responsible for the damage to the car.
I had asked Brian to use the car to go to a doctor's appointment.
Were you separated from Brian at the time?
Yes.
So you called Brian. And who was Brian living with?
His mother.
And the plaintiff?
Yes. I had asked him to use a car to go to a doctor's appointment. He had told me, let me call you back. Let me call my mother and ask her if it's okay. He called her, called me back.
No, you don't know what he said to his mother.
No, I don't know what was said.
But he called you back and said what?
Yes, it is okay for you to use the vehicle.
Fine.
He came, he picked me up, I dropped him back off at home, and from there I went to my doctor's appointment.
Where was your doctor's appointment?
In Apple Valley.
Did you go alone?
Yes.
So you drove alone in the car?
Yes.
Both going there and coming home?
And when I went back, I picked up my friend to give me a ride from Brian's house to back home to where I live.
So after you finished with the doctor's appointment, you picked up a friend, and the friend was supposed to do what?
She was following me over to Brian's house to pick me up from there and take me to my home. Because
So you're driving a car, and your friend is driving in another car?
Yes.
So you're always alone in the car?
No, I had a friend with me in the car.
What friend did you have with you in the car? And where did you get her from?
She was the friend that was coming with me. When I went to pick up the car.
Pick up what car?
When I went to pick up the car from Jim's house,
just a minute. First, this is Jim.
Yes.
I thought Brian came and picked you up.
He picked me up from my home to get the car. But this was after the doctor's appointment when I went to go to my friend's house for her boyfriend because she doesn't have a driver's license for her boyfriend.
Now we're getting someplace else. Just a second. Ms. Chapman, we're going to get the story straight. I want you to understand that. You had Brian's permission to take the car and go to a doctor's appointment and then come home.
No, I had told him that I had to pick up a friend to get my own ride back home, and he said that was fine.
So you picked up a friend after your doctor's appointment, and your friend was driving in your car with you?
Yes.
And where did you go with your friend?
We went back to Brian's house.
Fine. So now you drop off the car. Where was the accident?
On the way leaving my friend's house when I had picked her up. And they were following me. I went through the desert and I hit a rock.
Went through a desert?
It was a shortcut through.
You took a shortcut? On a dirt road?
Yes.
And you hit a rock?
Yes.
And that's when the whole axle broke on the car?
Yes.
So explain to me, Miss Chapman, why you are not responsible for the damage.
Because he's saying that I did not have permission to use a car. I did have permission to use a car. When the accident happened, I called Brian and I told Brian what happened. He said, do not worry about it. I will pay for it.
Well, Brian's not here. Brian's not here. You're driving the car and you had permission to drive the car. Is that right?
Yes.
Why aren't you responsible?
Because he had told me that he was going to pay for it, and I said that was fine.
So sue him.
Yeah, he should sue him. He shouldn't be suing me.
You sue him because you have to pay for the damage. And if you have somebody that said to you, don't worry about it, I'll pay for the damage, then you'll be standing on that side and Brian will be standing on this side. Do you understand that?
Yes.
Let me see the bills to fix the car.
I also have photos of the damage.
Can I see it, please?
Yes, ma'am.
What is this lost wages for November 19th?
I'm a substitute teacher, and I had to take a day off of school and turn a job down in order to go retrieve the car. So it cost me $120.
Get that from Brian. By the way, just for my own information, did you speak to your girlfriend and find out whether Brian had ever called her?
No, I did not, and she wouldn't have given permission to use the vehicle anyway.
Well, you don't know that.
I know her.
Probably not.
He had permission to use the vehicle to go to and from work because she had already damaged their other vehicle. In fact, 2 other vehicles.
Would you describe the interior of the car, sir, when you went to retrieve it? Because I see you have cleaning and deodorizing here.
Yes, ma'am. There was a broken cigarillo butt in there and French fries all over the floor and dust from the desert. The exterior of the car was also covered in dust.
Talking about the interior of the car.
It was covered.
Did you stop for lunch?
Yes, I did.
Well, what'd you leave the car a mess for inside?
I was going to clean it before I took it back to him, but obviously I couldn't clean it if there was damages to the car, and a tow truck came and picked it up.
Well, why couldn't you clean it out before the tow truck took it?
Because I walked up to my friend's house to call the tow truck for I could do it, but somebody had called and said that a car was banded in the desert, and the police came and the tow truck came and towed it before I could get back to the car.
It's not a difficult case, Mr. Chandler. You have a judgment in the amount of $624.74. That's everything that you're suing for with the exception of your day's wages. Thank you. That's all.
These are excused. You may step out.
So the story that was told in court was entirely different than the story I got.
He didn't hear the story from me, so therefore he could hear whatever he wants.
I was told that she was driving with a friend and heard a noise and pulled over to see what it was and hit the curb at 10 miles an hour.
I just think that I'm happy that whatever happened happened and he stays out of my life.
The attitude I got was, take me to court. I'm not going to pay for this.
Yes, he could take me to court. I don't care.
I have allowed her husband to use the car to go to and from work.
The whole thing is that he says I did not have permission to use the vehicle, and as far as I knew, I did have permission to use it.
He loaned the car out to somebody else without my consent or knowledge.
The person that gave me responsibility to use it should pay for the damages.
I think justice is finally been served.
23-year-old assembly worker Steve Glinka is suing the mother of his child, 22-year-old Michelle Johnson, for the cost of a DNA test to determine if he is the father of a second child.
Order. All rise. Now, this is case number 29 on the calendar in the matter of Glinka versus Johnson. Parties have been sworn in. Judge, you may be seated. Ma'am, have a seat, please.
Mr. Glinka, you and the defendant have a child together. How old is that child?
She's 4. She'll be 5 in August.
And at some point you separated. How long ago did you separate?
About 3 years ago.
And after you separated, the defendant had another child. The
Yes.
child is now about 1.5 years or 2 years old. Is
Yes.
that right? And at some point she came to you and said, when that new child was about 1 year old, 1.5 years old, that she thought you might be the father.
Yes.
And I assume that there was reason that she thought that you might be the father, even though she had another boyfriend at the time.
Yes.
So according to you, you took a DNA test.
Yes.
And the test proved that you were not the father. You had originally agreed, according to you, that you would share the cost of the test with the defendant, but then you changed that she would pay for the whole test if you were not the father. She didn't pay for anything, and you want to be reimbursed because you paid the bill. That's what the case is about.
Yes.
What prompted you, Miss Johnson, to tell Mr. Glinka that this new child might be his?
Well, the fact that he looked somewhat like my daughter did when she was young, and she looked just like him when she was younger. And just the timing when I got pregnant, the time I was with him, and the time I got pregnant, it just came together. And I thought about it.
You had another boyfriend at the time.
Right.
Did he take a DNA test?
No, he didn't.
He never did?
No.
Why not?
We just assumed that our son was his and not Steve's.
Well, now that you know it was not his, doesn't he want to take a DNA test?
No.
Are you still with him?
No.
You're not with him anymore?
No.
Does he pay support for that child?
He's supposed to, but he doesn't.
Did he admit paternity of that child in a court?
Yes, he did. Well, not in court. It went through the hospital, and they established it through the hospital.
You got to keep your date book more accurate, Miss Johnson. In any event, what responsibility do you think, madam, that you have to pay for this test?
Responsibility.
Responsibility?
Well, I asked him to take the test because I did think that my son was his, and he said he did not want to because he did not want to pay for another child support for another child because I was initially going down to file for it.
Against whom?
Him.
You were going to go and file for child support against him?
Right.
Even though you had another boyfriend?
Right.
Okay, so I'm waiting. Go ahead, finish.
And like I said, I initially thought it was, his. So we talked about it and we agreed I pay half, he pays half, and that was the agreement. But then he changed it to if he was not the father, I had to pay the full amount back to him.
Well, did you agree to that?
No.
But you agreed to pay for half?
The half, yeah.
So why didn't you pay for half?
At the time, I lost my job right after we agreed and was unable to pay for it.
So you acknowledge that you owe him for half the test?
Half the test, yes, but not the full amount.
All right. Now, Mr. Glinka, why do you think, sir, that she should pay for the whole test, where your initial agreement was that you would each pay for half?
Our initial agreement was that if the baby was mine, she would pay half, I would pay half. If the baby wasn't mine, then she would pay me my half back.
That's not what you say, or it's not what she said. You both seem to indicate that at first you were going to share the cost, but after the test was taken, you said to her...
No, right at the beginning, we had an agreement that we would each pay half. If the baby was mine, then that would be it. Later on, the DNA diagnostic testing started calling me, telling me that they wanted the other half of the money. I called her, asked her why she didn't pay her half. She says she don't have the money. I was like, all right, I will pay your half. If the baby's not mine, you pay me the full amount back.
I said after the test was taken, you changed the agreement. That's what you just told me.
Yeah, because she didn't pay her half.
After the test was taken, you changed the agreement for the whole test. Now, Mr. Glinka, At the time when this child was conceived, was Miss Johnson living with somebody else?
No, she was, yes, she was. Yes, she was.
She was?
Yes.
And you were still seeing her?
On and off, yes.
And you were still intimate with her?
Yes.
You see, now, if you hadn't been intimate with her, sir, you wouldn't have to worry about paying your half.
I know.
Right?
I know.
Right? So I don't feel so sorry for you, sir. We understand each other?
Mm-hmm.
She has to pay for half the test. Judgment for the plaintiff in the amount of $270. Listen to me. If you don't have an order of filiation legally declaring somebody to be the father of this child, then they are not required to do anything. And if I were you, I would take a quick hopscotch down to the family court or the local domestic relations court, file an appropriate case, and then have your current boyfriend or the person you think might be the father of this child tested. The child, I don't care about you. The child is entitled to know who the father is for a lot of reasons, including medical history.
Excuse me.
What?
I have my witness that heard her say over the phone that she would pay me the full amount.
She wasn't even there.
Listen to me, sir. Listen to me very carefully. If all you could do was mail it in, then I would say to you, well, she should pay the whole test because she was just harassing you. You got away clean for $270. Under the circumstances, I would count my blessings if I were you. You got it? Good. That's all.
Parties are excused. You may step out.
She started telling my family members that the baby was mine.
The way he is with my daughter now, I'm happy that he's not his father, too.
It was relief after finding out that he wasn't mine.
When he's supposed to pick my daughter up, he doesn't show up.
We still have another kid together, my daughter.
He'll take her to his house, but then he'll leave her with his mother or another family member and go do what he wants.
I see her all the time.
Stay away from guys like him.
Keep it in your pants.
And now the next case.
Pay her half. She forced me into this. I don't want to live there, Your Honor.
Well, who cares whether you want to live there or not?
There's a lot more into this than you think.
She moved out. Grow up.
This is Judy Justice. Bailiff Cassandra Britt is standing in for Bailiff Kevin Roscoe, and Law Clerk Alexi Mincer is sitting in for Law Clerk Sarah Rose. Kensington Sears is suing his ex-girlfriend, Whitney Clark, for the remainder of rent money and a corgi dog.
Court come to order. All rise.
Have a seat, please.
Judge, case 3067, Sears versus Clark.
Thank you. Mr. Sears, you and the defendant were in a relationship, and from what I gather from your papers, you entered into a one-year lease to live together.
Yes, Your Honor.
Defendant moved out prior to the termination of the lease. You want her to be responsible for the remainder of the lease from the time she moved out until the termination of the lease. That's your first cause of action. Second one is that you claim that as a result of self-help, the defendant came in and helped herself to your dog.
Yes, Your Honor.
Defendant says it's her dog. Her defense to your action is that she was forced to move out because of your violent behavior. The dog is hers. She paid for the dog. And she's countersuing because she says that there was a loan that she made to you a while ago, which she'll tell me about, and you kept some uniforms that belonged to her from National Guard. She wants those returned, correct?
Yes, Your Honor.
Okay. Why don't you tell me, Mr. Sears, when did you and the defendant start to date?
We started dating March 6th of 2020.
How did you meet?
We met on Facebook dating. We moved in together in June of 2020.
You lived in the same town?
Yes, Your Honor.
When you moved in together, were you working?
Yes, I was, Your Honor.
And you?
Yes,
working?
Your Honor.
Your agreement was to split expenses on this apartment?
Yes, Your Honor.
Correct?
Yes, Your Honor.
What was the rent?
The first move-in, our rent was just $350.
Just a second. You mean you moved into more than one apartment together?
Yes, Your Honor.
I'm talking about the apartment. Let's move forward. You lived in June of 2020 in one residence. Did you subsequently move into the residence that is the subject of this lawsuit?
Yes, Your Honor.
On what date was that?
January of this year, Your Honor.
Now, Ms. Clark, when you lived in prior residences with the plaintiff, you were also employed?
Yes, Your Honor.
And you split expenses?
Yes, Your Honor.
Okay. And that was the same arrangement for this apartment?
Yes, Your Honor.
And you're both on the lease of this apartment?
Yes, Your Honor.
What was the rent?
It's $850, Your Honor.
Now,
There came a time after you moved into the apartment that you made a suggestion about inviting in another roommate.
Your Honor, that was true. However...
Wait, just a second. That's true. Well, let's start with that.
Okay.
In what month did you want to bring in another roommate?
It was early February, it had to have been.
And who was that other roommate?
My best friend's girlfriend and her daughter.
They move in with you, the two of them?
They eventually moved in for temporary.
Just a second. Did they move in with you?
They did not sign a lease.
I didn't ask you.
Yes,
Let's not be tricky with me. Did they move in?
Yes, they did, Your Honor.
On what date?
Would have been the end of February, Your Honor.
So two of them moved in. Were they paying rent?
They were paying rent at the beginning, yes, Your Honor.
How much?
There was an agreement for $600.
Just a second. And when was the first check made out for rent? Was that February or March?
It would have been late March, Your Honor.
So she's paying half the rent.
Yes.
To you?
No.
To whom?
To the landlord, Your Honor.
So what are you doing here? The rent is $800. She's paying $400. You're paying $400.
She's not staying there the remainder of the lease. She's not on the lease, Your Honor.
I don't care if she's on the lease or not. She pays directly to the landlord. What does that have to do with whether or not you're out any money?
Correct, Your Honor.
So what are you doing here about money? You're not going to get any money from her.
Your Honor.
You're whole. Listen to me. You're whole. You know you're slippery.
My apologies, Your Honor.
I just get the sense you're slippery.
I try not to be, Your Honor.
Now, I don't care what happened between the two of you. You brought in another roommate. You're still there. You want her to pay her half of the rent. Pay attention. Slippery, pay attention.
Okay.
What you're suggesting to me is on an $800 a month rent, you were supposed to split the rent. She moved out. You have somebody who's living in the house now who is the daughter of the mother of your best friend's girlfriend who is paying you $400 a month. So if I award you from the time she moved out until the remainder of the lease, you come out ahead.
No, I won't, Your Honor.
You come out ahead. You have no rent.
I had to pay all the deposits all over again.
Just a second. You have no rent.
I don't want to live there, Your Honor.
You don't want to live there?
No, Your Honor.
Well, who cares whether you want to live there or not?
She forced me into this and then made me pay the deposit all over again.
Just a second. Forced you into what?
A whole new lease. I was already in a lease, Your Honor.
You mean you're talking about the apartment you just moved into? The apartment that we're here about?
Yes, but Your Honor, I was living at a place I was happy with before this.
Oh, who cares? Mr. Sears, grow up. Grow up. Let's talk about the dog.
Am I allowed to ask a question about his, what he's stating?
You're not allowed to ask a question about it. The only one who asks questions here is me.
Okay.
Did you hear anything that isn't correct? Is the dog at her mother's house? That's a yes or a no.
Kensington Sears claims his ex-girlfriend, Whitney Clark, wrongfully moved out and took his corgi. Whitney is countersuing for an unpaid loan.
When was the dog purchased?
May 25th, Your Honor. And
Of
I have
what
the
year?
invoice right here.
Just a second. May 25th of what year?
This year, Your Honor.
2023.
And if you notice, the invoice is in my name, Your Honor.
I don't care if the invoice is in your name.
Okay.
Is the dog purchased from whom?
I purchased the
No,
dog.
just a second. That's not, my answer slippery. I said, who was the dog purchased from? Not I purchased the dog. Who was the dog purchased from?
A breeder in Texas, Your Honor.
Okay. And you don't live in Texas, do you?
No, Your Honor.
Where do you live?
I live in Stillwater, Oklahoma.
How did the dog get to you?
We drove all the way to Texas to get the dog, Your Honor.
So I assume that this is a purebred corgi.
Yes, Your Honor.
Okay. You have a photograph of the dog?
I don't have a photo.
I'd like to see it. Oh, pretty dog. You know who had corgis?
Queen Elizabeth, Your Honor.
She did. It was her breed of choice. Was the dog registered?
Yes, Your Honor.
In whose name?
Both of ours, Your Honor.
Can I see?
I have it on my phone, Your Honor.
I'd like to see it. You have the registration?
No, Your Honor, she did the
Just-
registration online.
I'd like to see it.
After the purchase. Your Honor, while they're looking back at that, can I say one more thing about the rent? I have evidence that state that she said that she would pay her half.
Mm-hmm. Good. Okay, so the dog is jointly owned by both of you. Here, would you want to send this up to him?
Your Honor, that registration's done online after the fact. Anybody can do the registration. Anybody.
Mr. Sears, that's absolutely true. You didn't, did you?
I did not.
Shh. You didn't, did you?
No.
And it would seem to me, Mr. Sears, that if she was trying to make her case that the dog belonged to her, she wouldn't have put your name down as the owner.
I have evidence that says that she didn't want the dog.
Oh, I'd like to see that.
She didn't want to take care of the dog, as a matter of fact.
Just a second. I don't know what date this was, but this suggests that she was upset because the dog chewed up something.
She tore up the carpet. And I got videos and evidence showing where I took the dog around town. I took her to campus to meet students. I took her to my friend's job. We were running around with the dog every day. We were with that dog. She never once took care of that dog.
What I'm telling you, sir, is that you had the dog for 5 weeks, the two of you together.
Yes, Your Honor.
5 weeks. Not a long time. It's almost like the time that you might spend fostering a dog. So nobody developed a years-long attachment to this animal, or 2 years, or 3 years. You got the dog at the end of March, and you had the dog the month of April.
Yes, Your Honor.
Right? And May, you had a big fight, and she left the beginning of May, May 3rd.
Yeah.
So the dog wasn't with either one of you all that long. Okay. Where is the dog now?
She is at my mom's house, Your Honor.
What's she doing at your mother's house?
She's
Be very, very careful with me. She's at your mother's house. Where are you living?
I am living between my brother's house and my mom's.
How long has the dog, I think the dog's name is Cookie?
Yes, Your Honor.
How long has Cookie been staying at your mother's house? And I'm going to call her if I don't get an answer that I like. Do you understand that?
Yes, Your
She
Honor.
won't know what the call's about.
Yes, Your Honor.
How long has the dog been living at your mother's house?
Since May, Your Honor.
And he's in the apartment?
Yes, Your Honor.
He's getting the dog back. Do you understand?
Yes, Your
He's
Honor.
getting the dog back. Where do you come from?
Stillwater, Oklahoma, Your Honor.
Oklahoma. Yeah. And you want to go back there, right?
Yes.
You want to go back there?
Yes, Your Honor.
Very good. Well,
Can I add something?
you're going.
Am I allowed to say something, Your Honor?
I don't need you.
Okay.
I mean, if you had the dog living with you, then I'd have a discussion. But clearly, Mr. Sears is correct, at least about one thing, and that is that you were unable to take care of this dog because from the time you moved out, you gave the dog to your mother, and you move around. I don't know who you're living with.
Am I allowed to ask a question about his, what he's stating?
You're not allowed to ask a question about it. The only one who asks questions here is me.
Okay.
Did you hear anything that isn't correct? Is the dog at her mother's house? That's a yes or a no.
I'm talking about what he's suing her for. I thought he was suing her for $800.
He's not suing her for anything. I dismissed that part of his claim. He's not getting rent. Pay attention. Don't have a story fixed in your head.
No, $800 for the dog. He didn't want
No.
the dog. He wanted money for the dog.
No, he's not getting money for the dog.
I don't want money
He's
for
not
the
getting
dog,
money
Your
for
Honor.
the dog.
Okay.
Pay attention. Okay. By the way, you have family in Oklahoma?
Yes, Your Honor, I do.
Who?
My mother lives in Enid. My sister lives in Perry. My brother's
How far away does your mother live from her mother?
roughly an hour and 30 minutes or so.
Does your mother like the dog?
My mother loves the dog.
Okay. When you leave today, you're going to call your mother, and your mother is going to make arrangements to meet halfway, to meet his mother, and your mother is going to transfer the dog to his mother so that when he gets home, he gets the dog. Do you understand?
Yes, Your Honor.
As soon as that happens, you get your airplane ticket and your appearance fee. Got it?
Yes, Your Honor.
Okay. You say that you've made a loan to Mr. Sears. In what month and year did you make this alleged loan? If you have to think about it, you have no case. but I'll let you think about it for a second because it's your counterclaim. You should have these answers right at the tip of your fingers.
Kensington Sears has accused his ex-girlfriend, Whitney Clark, of taking his corgi and leaving him with the balance of their lease payments. Whitney claims Kensington owes for an unpaid loan.
So, Mr. Sears,
Yes.
you don't get your money because you're whole. You have a tenant. Tenant is paying half the rent. You're paying half the rent. Not fair for you to live alone and not pay any rent. So you have to pay rent. But you're going to get your dog back. Now, we have a counterclaim. You say that you made a loan to Mr. Sears. In what month and year did you make this alleged loan? If you have to think about it, you have no case. But I'll let you think about it for a second because it's your counterclaim. You should have these answers right at the tip of your fingers.
I believe it was in December of 2021, Your Honor.
For what?
It was for a car loan.
Between December of 2021 and May 3rd, 2023, did Mr. Sears make any payments on this alleged loan?
I believe he made one, Your Honor.
You do? Well, when did he make one?
I'm not exactly sure, Your Honor.
Well, that's what happens when you make a loan. You keep a record. You make a loan how much it was. You make a loan what the payments were. How do you expect me to figure it out?
I'm not sure, Your Honor.
I'm not sure either. Now, how much was the alleged loan for? Now, you're looking up here, you're looking over there. That suggests to me you don't know exactly what it was for.
I believe it was $2,000, Your Honor.
Your Honor.
I didn't ask you a question.
All right.
Don't interrupt my train of thought. I'm an old person. I need all the help I can get, and being interrupted doesn't help me. I lose my train of thought.
Absolutely, Your Honor.
Then nobody will follow me, and then we won't have a show. Okay. Miss Clark, I want to explain something to you. I've read your answer and I've read your counterclaim. Your counterclaim said that the loan was $3,000. Here you say, well, I believe it was $2,000. It happened 2 years ago. Did he make any payments? I don't know. I think I made one. So what you need in order to have a loan, which is a contract, is a finite amount. What is the loan, which you don't know? What is the payments? I don't know. How do you expect a court to figure out your loosey-goosey finances? That's not our job. If you make a loan to somebody, you have to have an amount of money and a payment schedule.
Your Honor, I do have the payments. The payments were $210.
So did he make payments?
No, Your Honor.
Oh, and did you enforce the payments over 2 years?
Yes, Your Honor.
How did you do that? Did you take him to court? Did you sue him in small claims court? What did you do?
Well, we made an agreement for him to pay for the car because he told me he was buying the car for me.
Can you ask?
Oh, just shh. Sears, so far you're ahead of the game with the dog. I wouldn't say anything else if I were you until I ask you a question.
Absolutely, Your Honor.
So you drove the car?
We both did, Your Honor.
Well, you just said to me, he said he was buying the car for you. How many cars did the two of you have when you were living together?
2, Your Honor.
What make of cars? I was going to say what brand, but it's not a brand, it's a make. What make of cars?
It was a Dodge Stratus and
So who drove the Dodge?
I did.
And is that the car in question?
Yes, Your Honor.
Good. And for how long did you drive that car?
About a year, Your Honor.
Who paid for the car?
I did, Your Honor.
You made the monthly payments?
Yes, Your Honor. I have this bank statement right here.
Is that correct, Mr. Sears?
Yes, actually it is, but there's a lot more into this than you think. That was actually a title loan on my truck to get her the car. She's making payments
Where is
to
the
a loan
car?
company.
Just a second, where's the car now?
On the side of the highway, blew the rod on it.
Who did?
I was driving when it happened.
Okay. I had enough of you both. You have to move on with your lives, children. You get your dog back.
Thank you, Your Honor.
And I told you how that's going to happen within the next half hour. Get in the back and make it happen. Are you happy now?
Yes, Your Honor.
Are you happy now?
Yes, Your Honor.
Perfect. Be happy.
Thank you, Your Honor.
We're done.
Case is now closed. Court is adjourned.
I don't believe it's fair that he should keep the dog because I did pay for her and I sent him the money to pay for her, so it's kind of hard to explain.
I am ecstatic to get the dog back. That's all. That's the main thing that we were here for. It's one thing we really wanted. We just wanted to bring Cookie home.
It was because she was tearing up the apartment and I was afraid that we were going to have to pay for the damages, but what I really wanted was just get out of there and have her with me.
She was doing it out of spite. She was mad about the argument that ensued. And she wasn't happy with the outcome, so she did everything she could to attack me.
Because I felt like he was abusive and possessive.
She was mad. She come home late one night and her classmates had an assignment saying that she wasn't doing her part and she took it out on the wrong person.
It's been going on the whole time we were together, but it was really bad when we moved into her since March.
Oh, we're done. I'm so happy. I'm actually with a new woman now. She treats me right and I couldn't be happier.
I hope I don't have to see him again.
Cookie's coming home. That's great.
My takeaways, it's a classic duty to mitigate windfall case. She came into this lease in February, broke it in May, and the plaintiff may not like what she did, may have been annoying, but for that remaining time, he found someone else to replace her. And if you have that money, it doesn't matter to him what source it's coming from, he's made whole, and the court's not going to step in and give him a windfall.
Right. Smart. So smart to go to law school.
Nidra Hunter is suing business owner Tamika Young for a party bus refund and punitive damages.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 3018, Hunter versus Young.
Thank you.
You're welcome.
Miss Hunter, you were planning your wedding.
Yes.
And the wedding was planned for what date?
October 8th, 2022.
Miss Young, what's the name of your company?
Luxury Queen and Mr. Party Bus.
And where is it located?
It's in Detroit.
How long have you owned it?
Since 2017.
And it's a party bus company, then you must have party buses registered in the company name. We're going to check it. How many party buses do you have registered in the company name?
Well, actually...
No, not actually. That's a question that I have for you. How many party buses do you have registered in the company name?
None.
How many party buses do you have registered in your own name?
None.
So it's a fair statement that when you advertise that you're a party bus company, what you do is you subcontract that out.
Yes, ma'am.
You know where I'm going, right? Do you see any advertising under the name of that company? Because that's how the plaintiff got to the defendant.
I do. I see their Facebook page. In addition, they have a website.
May I see both, please?
Sure. Facebook page.
Okay, let me see. We have the best rates, limo service. Okay. Now, is this what is on their website as their party buses? Let's take a look.
So if you go about, when you go to book now, it gives you just these options, 4 options for vehicles, and then a place to leave your message. And that's it.
Got it. So what you did was, in anticipation of your wedding, you wanted a party bus to take about 30 guests.
Yes.
So that everybody was together.
Yes.
For photographs to a park, whatever it is, and get you to and from the venue to the party afterwards. And you looked on the internet and you found Miss Young's company.
Correct.
Your wedding was in October. On what date did you contact Miss Young?
It was in March.
Do you have any written contract or communication with her?
Text message.
May I see it, please? Who are you, by the way?
I'm the driver.
Are you related?
Yes.
How are you related?
I'm her nephew.
How old are you?
20.
I'll get to you in a minute.
I just found something interesting. So there's a video posted by the defendant on the work page on Facebook saying prom season is approaching with a video of a large white bus that looks like it would be about 25 to 30 people. And somebody in the comments inquired and said, interested, how much for 5 hours? And the defendant says in March of 22, this bus posted is no longer available. This one being she sends a video of a different bus, is 15 to 20 passengers for 5 hours is $11.50.
So in March
of
2022, she indicated that that party bus was no longer available.
Which looks larger than the one she suggested in the comments, saying the one that was originally posted about
You have a
prom.
date in March?
Yeah, March 12th, 2022.
And it was the defendant saying to another party.
A different party.
Different party, that bus is no longer available.
But here's a different video of a different bus that seats 15 to 20.
Got it.
Lists the rate for that.
Okay, so, very good. Well, how come you told her the bus was available?
That bus particularly was available in March.
No. You told somebody else that the bus wasn't available on March 12th, within 24 hours. So in March, when you were dealing with her and her wedding, you already told somebody that you don't have access to that bus anymore. That's what you...
That particular bus, but Your Honor, I have different types of buses.
You know what? You don't have anything. Monsieur, you don't have anything. We established that.
I have access
you
to it.
You don't have access to anything more than she has, more than I have.
I work with different companies. And
you are a subcontractor, and you make promises like you did to her, and then, because clearly, $950, she paid you.
Absolutely.
She paid you. And how many days before her wedding did you tell her that there was a problem with that bus? How many days before?
It was September 26th that I called and had a conversation with her. Would I have that information here that we had this conversation, that bus was no longer available because it was in an accident?
You know, I don't like you to think that you're really dealing with somebody that's stupid. You just told me that you have access to many different companies.
Absolutely.
So if you have access to many different companies and you've contracted for a 30-passenger bus that looks like that, use one of your other contacts. I wouldn't use your company ever. Because what it was is a bait and switch. You baited her with a 30-passenger bus that she needed.
No.
3 weeks before her wedding, you say, that bus, either you told her was in an accident. According to your answer, you said it was having mechanical difficulties. Is that correct?
Absolutely.
Is that correct? Well,
mechanical accident, same thing.
No, it's not the same thing. It's not that, and you don't own the bus. It's not the same thing, and you don't own the bus.
I have access to it. I have access to it.
I'm going to tell you, madam, it's a bait and switch. Now you can stand up, because what happened was she sent you a smaller bus. You want a refund.
Yes.
That's the bottom line. Move over here. You have a chauffeur's license?
Yes.
Take it out. May I see it, please? Well, you didn't have a commercial driver's license in October of 2022.
I was trying to be.
I don't care what you were trying to be. Your commercial license wasn't issued until January of 2023. Is that correct?
Yes. I'm a school bus driver. I had to get that as for the drive. I had a chauffeur's license at the time when I was driving them.
You needed this to drive a commercial bus, and you didn't have it at the time that you were driving. Okay, so first you arrived late, right?
Yes, but that was because I had the wrong address.
Who gave you the address?
It was on the itinerary.
That she gave you?
Yes.
That's the information that she gave me.
Impossible.
I promise you.
Just a second. You live in the same community?
I live in Detroit, but Detroit has different counties, different cities. Yes.
Transportation is your business. What was the name of a hotel she was staying at?
I didn't even know it was a hotel that she
What was the name of the hotel?
I cannot remember off the top of my head.
Okay.
Holiday Inn.
Okay. Listen, I'd like to give you money for your aggravation, but you got married, right?
Yes.
You happy?
We are.
This your husband?
Yes.
Are you happy?
Yes.
Look happy. All she should say to you is, I'm sorry, because it was clearly, in my mind, a bait and switch. She baited you for a 30-passenger bus, which she did not have. She never told you she was subcontracting for that bus, did she?
No.
Of course not.
I explained.
Nidra Hunter claims business owner Tamika Young owes her a refund after bringing the wrong size party bus to her wedding.
Now, based upon the website, you would assume and the photographs and the videos that are on Facebook, you would assume that your company provides buses that you own, not that you subcontract to other people. There's no question in my mind that's a bait and switch. That's what it was. And I doubt whether you ruined their wedding because they tried to make the best.
I tried to make the best of her wedding. I reached out to her. I called her. I let her know what bus I was switching her out to, which I have the video here.
Bait and switch.
I understand you said it's a bait and switch. I get to the bottom of it, but I did kind of accommodate her when the situation. I offered her a refund.
You offered her a refund. She paid you $950. What did you offer her?
$950.
You offered her $950.
Absolutely.
In cash.
Absolutely. The day when I switched her bus.
Just a second.
Then again, when we got there.
That's because that's not what I read. I read that you offered her something towards her next ride. You offered her the $950?
$950.
That's what she's going to get, $950.
That's what the contract was.
Just a second. Did you?
And then when Antoine got there and she wasn't happy with that bus due to when I explained to her over the phone conversations that this 15 to 20 passengers, if it's tight, different.
You know, it's a hustle. What your website is a hustle. He is not a professional driver. He's a 20-year-old kid who couldn't even get to the right address. Who got there late. No, she didn't give you a wrong address to get to her wedding.
I asked her for her information and she sent it to me.
And you bait and switched her with a large bus. And at the end of the day, it's not easy to. Yes, you did. $950, judgment for the plaintiff. That's it. We're done.
This court is adjourned.
I work for different companies. I am like a booking agent. She said I'm subcontracting, but I work with people that have these buses.
I think it went well.
We do have buses that's no longer available because those are not available anymore.
She didn't give us the proper bus. It didn't hold our wedding party, so a lot of people couldn't show up.
They didn't accommodate because she had big people.
It was very sad and heartbreaking. My kids couldn't be there, my brother.
We was there. We gave the service, even though it wasn't that bus. And they had a wonderful time. They played. They had fun on the bus. They danced. They took pictures.
No, I mean, we made the best that we could out of the situation.
When I accommodated to give her a refund the day of the event, she didn't want it. She wanted the bus.
Never will work with them again.
You know, I think I have a personal, as much as a judicial, negative sense of business people like this woman who clearly has a business that she operates out of her kitchen because she doesn't have any transportation vehicles. She will get a client from a website, and then she'll call around and see what vehicles from other companies are available. And then she has a nephew, maybe a son, maybe another nephew, maybe a gotcha. And she'll get a driver, because he said that he drives a school bus.
Yes.
I don't know why somebody would let him drive a school bus when he's 19 years old.
Issue for another day.
But that's for another day. But you don't realize when you do that, somebody spends a year planning a special day.
Of course. The business plan is all messed up from the jump.
Yeah.
I think when you are offering what you call a top-tier service and you don't actually own or have control over any of the assets necessary to run that business, then you're waiting for trouble because
you're waiting to disappoint people.
Exactly. It's all going to be a disappointment, but lucky for the defendant, she's never at fault because it's not her bus.
Yeah.
So she never, I couldn't get access, I couldn't this, I couldn't that. It's always a push-off. Yeah. And so for people like the plaintiff, make sure when you're interviewing companies that, number one, they own the assets that they're alleging, that they have full and complete control over those. So if they say there's a conflict, you know who to go after in that situation. So unfortunate, but the right thing happened.
Yeah, and she's married. And she says she's happy.
Case number.
Hi, xin các bạn. Chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh một nhân vật trong hoạt hình Pokemon. Màu xanh nhạt, tô vàng, tay và thân. xanh đậm vào tay. Xanh đậm mình sẽ tô vào đây. Vậy là chúng ta đã tô xong bức tranh một nhân vật trong hoạt hình Pokemon. Và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn. Chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh một cốc trà sữa. Mình sẽ lấy màu tím, tô vào nước. Mình sẽ lấy màu này tô cho ống hút. là chúng ta đã tô màu xong bức tranh Một cốc trà sữa và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn, chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng tôi cùng tô màu bức tranh một chú chó bên cạnh một quả bóng màu xanh này, tô vào quả bóng. Một đỏ và vòng cổ.
Bố cho à? Vâng. Thật không? Nó hỏi bố đi đã. Đấy, xem tivi thấy chưa? Đấy, xem tivi đi.
Các chị ngồi. Bạn chuồn ăn. Bạn chuồn ăn chứ. Chị ơi. Cho chuồn ăn không? Bạn chuồn ăn.
Vậy là chúng ta đã tô màu xong bức tranh Một chú chó đang chơi với quả bóng và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn, chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh những chú Pikachu. Mình sẽ lấy màu vàng này tô cho chú Pikachu. Vậy là chúng ta đã tô màu xong bức tranh ba chú Pikachu và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn, chào mừng các bạn đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh nhân vật trong hoạt hình Pokemon. Mình lấy màu này tô cho mặt. Ok, mình sẽ tô vào đầu. Bằng cam mình cũng sẽ tô vào chân. Mình sẽ lấy màu đỏ tô vào đây. Vậy là chúng ta đã tô màu xong bức tranh một nhân vật hoạt hình trong Pokemon. Và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn, chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh ông và cháu nha. Mình sẽ lấy màu đen tô vào tóc của cháu. Màu xanh này thuộc về áo. Áo ông sẽ không màu nâu. Màu đỏ vào lưỡi. Áo đen và quần của cháu. Vậy là chúng ta đã tô màu xong bức tranh hình ảnh ông và cháu. Và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, xin chào các bạn. Chào mừng các bạn đến với kênh của mình. Hôm nay chúng ta cùng tô màu cho bức tranh về một cô bé cắt uốn tóc hai bên đang chơi cùng với búp bê nhé. Chúng ta cùng bắt đầu thế nào. Sẽ tô màu hồng vào hai chiếc nâu. Tô cho búp bê vào đen. Hi, xin chào các bạn, chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh một chú chó. Mình sẽ lấy màu xám tô một chú chó. chúng ta đã tô màu xong bức tranh một chú chó và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo. Hi, chào các bạn, chào mừng các bạn đã đến với kênh của mình. Hôm nay chúng ta cùng tô màu bức tranh một chú xíu. Mình sẽ tô màu vàng ở đây. Mình sẽ lấy màu với nhau tô vào đây. Màu đen và chân. Vậy là chúng ta đã tô màu xong bức tranh một chú rết và đây là thành quả ngày hôm nay. Hẹn gặp lại các bạn ở những video tiếp theo.